holding activity.
May I suggest that we stick to the time you have allocated us, and you have the discretion to allow anybody, including my learned senior, the Honorable P.K. White, any flexibility.
I think that's what we did last time. We allocated time, but we were flexible enough to add time whenever it became necessary. So with those submissions in mind, I will give you the time allocations which we have given, but with the latitude to grant more should it be necessary.
My Lord, I was going to request that because we are prosecuting these applications, that we just say that officially so that you don't think I don't feel pressure that 30 days. This is a kind of case, my Lord, that if you do not argue it, inevitably this case will somehow have that. I don't want anybody to accuse me. I did not argue this or the other when I had an opportunity. 30 minutes will not bring heavens down. It is only 15 minutes to enable me to do the job, not for myself and my clients.
My Lord, here we go again.
Let me speak. This is a court of law. I respect you very much, Council, Senior Council, and all the Council here. But please let us appreciate that this is a court of law. And when directions are made, please let's respect those directions. I'm making this direction. We have allocated time. Should it become necessary for one party to ask for more time, we will consider that. Thank you.
My Lord, the first application in which we have filed these documents in the file officially called petition number E015 of 2024 is an application dated 21st of October 2024. It is supported by an affidavit that has been sworn by this affidavit has been sworn by the Honorable David Ngunyi Mabenge. It is further supported by a supplementary affidavit that is 21st, a supplementary affidavit of 24th of October 2024 by the Honorable David Mabenge. In addition to that, we have filed a bundle of authorities, which I believe that they have been furnished to the court. My Lord, looking at my watch, it is 3 p.m. I am certainly going to require some additional time, but let me start and see how best we can manage the time that has been allocated. Well, in the ruling that you delivered yesterday, you made a significant point that this is a matter of extreme public importance that deals with the most weighty issue that can be conducted, both with regard to the office that it relates to and to the issue of political succession. My Lord, the issue of political succession countrywide is an existential issue of the state. Existential issue of the state in the sense that this is an issue that when you read Professor Namwebe, Ben Nabweze, and when you read all these cases from Pakistan, they are the most weighty constitutional issues that can appear before any group of judges. And my Lord, for purposes of this country, we are saying that for the 2010 constitution, the matter before you, and that is why has informed the filing of this application, is one that is an existential issue for purposes of the 2010 constitution. Your Lordships, I say...
Your Honor, sorry for interruption. You have been muted. I am unable to follow proceedings. Okay. Now it's okay.
My thought process is affected now. Yes, my lord. So I was submitting and saying that it is an existential issue for two reasons, my lord. My lord, most of us who are at least practicing for 20 years are aware of two provisions of the former constitutions of Kenya. We used to have a section 23 of the Kenyan constitutions, in which all executive powers were vested in the president. That position radically changed under the 2010 constitution. We used to have section 30 of the constitution, in which parliament meant the president and the legislature. My lord, those positions changed. The change of those positions, which is the submissions that we are making, the impeachment proceedings would have the consequences, if it goes the way in which it has gone, of effectively bringing back to life sections 23 and sections 30 of the former constitution. Now, the second issue that I need to emphasize on the existential issues of the constitution is this. My lord, from the standpoint of the constitution and to safeguard constitutionalism, there is these issues that is called security of tenure that certain offices enjoy, particularly with regards to the questions of removal. My lord, the two offices that enjoys the greatest tenure are the office of the president and the office of the deputy president. My lord, why is that the case? Because they are legally protected that to remove a president or a deputy president, you need impeachment. They are also secured by the electoral process, that those two people, to get to those offices, they must be voted into those offices by the people. But the significance of this is this. Every other holder of the offices, from constitutional office holders to judges and everybody else, doesn't enjoy political tenure. It is only legal protection for those particular offices. So that, my lord, the point is this, that the true weight of this matter is this. If it were to turn out that an office that enjoys the greatest protection, like the office of the deputy president, can be called, the removal can happen as we are alleging it happened in this case. My lord, the whole scheme of constitutional tenure and protection that is necessary to protect our democracy would effectively be null and void. This would mean if you have numbers, you do not like the speaker of the day, you can get him out. Numbers in a democracy, and that is why you write the constitutions, numbers must be controlled by law. If we reach a position where numbers cease to be controlled by the law, my lord, that would effectively have negated all the constitutional gains that this country has gained. My lord, having made that point of the nature of the issues that you are dealing with, let me come to the issues before you. My lord, the petitioners, or in those cases, in those affidavits, in the applications, are saying a fairly simple issue. They are saying that as a result of events that occurred in Kirinyaga, that are partly the subject of the yesterday's decision that was made, and as a result of other matters that is the subject of the supplementary affidavit, the petitioners feel, and the petitioners are of the strong opinion, that a case of this magnitude is not the kind of case that should be decided by a bench in which they do not enjoy full confidence in. My lord, the basis of that, since this is highlighting, would be four. My lord, on the first issue is that the petitioners, and in the applications that they did and is a subject of overruling, they pointed out certain issues that brought into question the issues of the